Well, thank you, Dennis. I'll have to go without a mic for now, and I apologize for that. I think Dennis introduced this as the dream team, and I would say that I'm probably the only nightmare part of it. But again, I want to thank the West Virginia National Coalition for putting this together. I also want to thank Assistant Secretary Main and Deputy Assistant Wagner for making the filming of this available. We're hoping that this will be put on some kind of media that we can share with some of the other doctors. There are about 150 who perform DOL-sponsored exams. These are exams that are paid for by the Department of Labor. We ask that physicians give us an independent assessment of the minor's condition with the recognition that that condition changes. At some point, if a physician is examining the patient may not at that time have the disease, or may have the disease and has not progressed into a totally disabling pulmonary condition. And that's recognized in our regulations, and minors are permitted to refile their claim. So recognizing the fact that if a minor has CWP, at some point it can progress. There's a latency to the disease that occurs after employment, some years afterwards, and that is recognized in our regulations. And that was promulgated in our 2000 regulations. Just a couple of quick notes. We've passed out the last page of our medical report form, the CM-988, for your review, and we're going to focus on the real questions that need to be responded to, and where we get into issues such as where a physician is exercising their judgment and making a determination whether the minor has coal workers' pneumoconiosis, whether it arose from their coal mine employment, and whether they are totally disabled from it. Those are the three major questions that have to be answered. And Mrs. Profit, in her prior presentation, talked about the importance of the physician in giving an examination, and I would certainly say that that is true, but it is also true that that examination must lead to some valid conclusions that are based on the objective evidence of record, and that's where we run into issues when the cases go into litigation. Some of the physicians recognize that the minor has the disease or is totally disabled from it, and they just don't adequately document that. It's hard to translate medicalese into legalese. So we ask our physicians who perform these independent exams that are paid for by the Department of Labor to give us those views. It is extremely difficult. We now have 5 of the most seasoned physicians who actually conduct these exams that can focus on these questions. Under 718-201 of our regulations, pneumoconiosis is defined. It was regulatorily defined in our 2000 regulations to include COPD. Okay, that if it can be linked to coal mine employment, that is a very important distinction for our coal miners who file their claims with us or their survivors. We have the clinical presentation of disease, which is classical, and that's not much in contention. You have your x-ray evidence, your autopsy, etc. It's a restrictive defect. But where we run into problems is where the disease is defined as obstructive. So was it significantly related in some way to the minor's condition? That's the link that we need from the doctor. First, to diagnose it. And so what we're going to do is probably go in 3 stages. The first thing is, obviously, the medical report form itself. There are pages where the physician goes over the medical history of the minor, and most importantly, their occupational history. That is key. Also, the exertional requirements of the job, because that makes a play into whether the minor is totally disabled from their last coal mine employment. These are very important issues. So I think the first one I'm going to turn to the panel for, and do we have a mic that's active, or are we going to have to? Those are the ones that are, yeah, that's one. Is that active? Good. Maybe we'll pass that around, but the first thing I want to pose to the minor, or to the doctors, and I think, now you can hear me.
We've got 6 distinguished speakers there. I drafted Dr. Pitzel.
Okay. Well, great. That's an additional. So everybody will, let me go over a couple of quick, and I'm probably not doing justice to the panelists, but I'll just do a very brief summary. We have Dr. Rasmussen, who's already been introduced. His primary is internal medicine, operates out of Beckley, West Virginia. and he's licensed in West Virginia, and a graduate of the University of Utah Medical School. And if I'm wrong, correct me on any of this. Number 2, we have Dr. Dominic Gaziano, and he operates out of Charleston, West Virginia. He has a license to practice in West Virginia. His primaries are under internal medicine, his subcategory, critical care and pulmonology, and that was the Virginia School of Medicine. If I've misstated that, let me know, Dr. Gaziano. This is pulled out of Google. Then we have Dr. Robert Cohen. He is certified in internal medicine, operates out of Illinois with an Illinois license. Critical care, pulmonology, Northwestern University, Feinberg School of Medicine. Then we have Dr., let me look down and see who we have. Okay, Dr. Srini Amisetti, and he operates out of Stanville, Kentucky. He's in internal medicine with a primary in pulmonology, graduate of Guntur Medical College. Then second to last, we have Dr. John Randy Forehand. His primaries are pediatrics, allergy, and immunology. He operates out of Richmond, Virginia, licensed to practice in Kentucky, Virginia, and West Virginia. He puts in a lot of mileage on his vehicle. Dr. Petsock, University of West Virginia, was, and I may get this wrong because I didn't Google you, I'm afraid, Lee, but with NIOSH for a period of time till he retired. Extensive work in disease, especially chest diseases and co-workers pneumoconiosis. So with that, I'll not want to take up any further time. So let me introduce the first topic that we're going to talk about, and again we're dealing with a cardiopulmonary diagnosis, and again under COPD, is it significantly related or substantially aggravated by? Those are the tests and what we would want the doctors to address. And I'll start out with Dr. Rasmussen, who's had many years of doing these, and I guess back to 69 or plus, and we appreciate him on this panel.
Well, if you're going to dealing with COPD, chronic obstructive lung disease, of course, you have to first of all determine that an individual had adequate exposure. You have to also look at the other potential causes of COPD and emphysema. Clearly, you can't ignore cigarette smoking. You also have to consider whether we're dealing with someone who has asthma. And your own job in your own mind is to try to determine how much of his impairment you feel is attributable to his coal mine dust exposure, whether he has x-ray evidence or whether he doesn't. And that's where you have to be aware of some of the medical literature, some of the statistics, some of the epidemiologic studies that have been conducted to allow you to make a judgment in that regard.
Okay, thanks, Dr. Gazio.
Well, I agree with Dr. Rasmussen's point of view. You have to look at all things, but I think in terms of a practical point of view, that I think I've been involved with this program for a long time. There's an administrative aspect of it that if someone's been involved in the coal mining industry for a certain number of years and underground, that there's a presumption then that any COPD is contributed to by his occupation working in the mines. And of course, cigarette smoking is a very important part of this. I think also Dr. Rasmussen's pointed out in the literature many times that I've read is reviews, and actually in the American Review of Respiratory Disease in October of '09 clearly points out that coal mining produces COPD. So I think the issue is pretty well established if you've had significant exposure to coal and rock dust. Then the other issue has to do with impairment, and maybe we can go into that.
Yeah, we will.
While I have the phone, the thing, I do want to say one thing about complicated pneumoconiosis, that in my experience, that it is irrebuttable, but I find oftentimes it is successfully rebutted, and I have an issue with that so much of what's considered complicated pneumoconiosis is complicated pneumoconiosis ascribed to something else, and that's an issue that I suppose the legal aspect needs to address.
Dr. Ghazi, may I make one comment? I might ask the physicians to comment on what objective basis that they find in their reports as far as making an objective basis for their diagnosis of whether clinical or statutory disease, because I think that's very important, and that's where we run into problems in all three of the categories that we're going to discuss. Thank you.
Thank you, Steve, Don, and Dom. I think that the most important thing is really putting clear reasons down for one is why you make the diagnosis and what supports it. And I think that I've heard from my legal colleagues that what they see is somebody writes just COPD, and they write coal dust and tobacco, and then they're done. And they think that it's disabling. They say it's disabling, and just putting the word of the diagnosis down there without saying how you made the diagnosis of COPD. So you've got to say if you think it's COPD, how do you make that diagnosis? And that's usually from lung function testing that shows obstructive impairment that's not reversible and that's significant. If you make a diagnosis of chronic bronchitis, you need to say what you did, how you made that diagnosis. Did the patient give you the history for that? If you make a diagnosis of scarring in the lungs, which is what we call clinical pneumoconiosis, that you think the coal dust caused all of these scar tissue to form in the lungs, you need to say how you made that diagnosis. You can't just write CWP because I said so, because I'm a doctor and I went to medical school and therefore everybody should believe me. Many physicians, we don't like to have people question our diagnoses because we're, as Debbie Wills would call us, doctor gods. But even though we are, or some of us think of ourselves as doctor gods, we need to really very carefully put how we made these diagnoses in the supporting information. So if it is CWP, we saw scars on the x-ray. I made the diagnosis by x-ray, or there's lung function studies that go along with scars, like diffusion impairment or exercise changes in oxygen levels that make me think that there's scar tissue in the lungs, or there's a pathology specimen that shows it. You must state how you made that diagnosis. That's very, very important. And so whether it's COPD, scars in the lungs, what was the criteria that you need to make the diagnosis and support that? And then you have to say what caused it. And you can't just say it's coal dust. You've got to say why you think it's coal dust, or coal dust, as Don pointed out about tobacco smoke exposure. You've got to point out both of those things. So you can say, well, I think it was coal dust caused COPD because this person has 25 years of underground coal mining in a very low seam coal with significant exposure. Really describe the exposure so that the judges and the Department of Labor folks can get an idea of that you understand the exposure of this man. It wasn't that he walked past a coal mine and took a deep breath one day, but he actually was underground in pretty tough conditions and couldn't see his hand in front of his face, or whatever you can do to make that really come to life. Otherwise, you just writing coal dust on there will not fly, and you've done your patient a disservice. And don't make these diagnoses unless you can support them, because if you do that, you are going to do the patient a disservice. You saying COPD, if you can't prove it, makes your report useless. The attorneys can't do anything with it. It ruins the cases for the minors. So really make sure that you can really stand on what you do. And that's really important when we come to impairment. I don't know if you want to talk about impairment
we'll
now.
We'll get to each of those.
So anyway, I think that from my experience, the problem is people just writing a diagnosis without a clear justification, and then saying what caused it without explaining why they think that it caused it, and taking into account everything that could have caused it and what contribution you think that that had. So that's very, very important. You can't just ignore the fact that the person was a smoker. Say that it was coal dust and smoking, 26 years of packed years of tobacco smoke plus 23 years. That's why I think that his 23 years is very significant, but it's not the only thing. His smoking was also significant. So please take all that into account. Write it very carefully. Otherwise, we're doing a disservice.
Thank you. I think I agree with COPD emphysema. The black lung pneumoconiasis caused emphysema. But the problem is, when you're looking all the reports, company doctors pick up the smoking. Hey, this patient minor smoked for a long time. This is all emphysema caused by the smoking, so you don't get any benefits. This is due to the smoking. I think that's smoking. If you look into the data, only 20% of smokers get the emphysema. You agree? I mean, it's a very small number. When you have a small number of people get the emphysema with the smoking, but attributing everything to the smoking and deny the benefits. And I think it's a good thing Steve brought this paper, fourth paper, page 4. This is the one, whatever you guys judges talk or attorneys talk, minors talk, everything your benefits, even though you worked for 40 years in the mines, this is the report gives the your benefits. Whatever you write in this page, that's the one make the difference. So when you're looking for the pneumoconiasis black lung, we look for the physical examination. Physical examination, even though we put that one, if the guy breathing, even though breathing doesn't count into benefits. And even though it's coughing, bring up phlegm, doesn't count to turns into the benefits. It's all depend on the 3 things. One is the pulmonary function test, that's spirometry, blood gases, oxygen, and X-ray. Even though you guys had did 30 years in the mines, doesn't mean anything. So when you're looking these investigations, physical examination part contributing helps but not the decision making, the 3 things. So when you look, those are the things we have an incomplete. It's not working. We don't have any full. I think it's not working.
You've been cut off, Dr. Amicetti.
So what I would like to do, I mean, these 3 things help a lot. And one more thing, also we need the Black Lung program educate our minors. This federal Black Lung program is total disability, not the partial. Partial disability, the state will take care about that one. To get the federal Black Lung, you have to reach the certain numbers. That is the 3 numbers.
Yeah, we're going to get into total disability in the next round. Thank you, Dr. Amicetti.
Good morning. I'm Randy Forehand. I'm another one of the designated examining physicians for the Department of Labor. And I'm not going to repeat what anyone else has said, but I want to voice a couple of personal observations. Number 1, it's a myth that only cigarette smokers get black lung benefits. While it's true that cigarette smoking makes a significant contribution to the impairment, occupation also makes a significant contribution toward impairment. I once heard a physician tell a patient, a coal miner, that if you plan on getting benefits, you better start smoking. But that's not true. Only about 15%, 1 in 6 smokers develops significant pulmonary disease. I also found it very important to ask the coal miner what in their opinion, why do they believe that the dust has injured their lungs? And you'd be really surprised if you give the employee, if you give your patient, the coal miner, the opportunity to articulate, to describe what the dust has done to their lungs. You will get a paragraph, you will get a book that is very moving, very persuasive, and I've never had 2 miners give me the same description. So it is critically important that when the miner comes for his or her examination, that they are prepared to explain, to make sure that the examining physician knows what their job consisted of, that they know how dusty the job was, and that they can explain in their own words why they believe that dust or their occupation has injured their lungs. You never want to mislead anyone about your smoking history, because those hospital records are out there, and your personal physician's records are out there, and that if you're being judged and there is inconsistency in your smoking history, that makes your claim much less powerful. So you must always give no matter how hesitant you are about giving a smoking history, because you believe that that is the only reason you might get a disability or be found disabled. That's not true. Always be truthful, because the records have to match, or it really will diminish the power of your claim. So again, and just to emphasize, don't shy away from the smoking history. Be sure that your examining physician has a clear understanding of what your job description was, including the dust exposure, and explain to them why you know that the dust in your occupation has injured your lungs.
Just perhaps one additional observation that may be useful, and that is that the argument often is made, you've heard before, that cigarette smoking causes severe lung disease and tobacco is the main cause of obstructive airways disease. But I think from the scientific literature, and this has been investigated and you can reference the literature, there is no evidence that an individual who is susceptible is more susceptible to tobacco smoking versus coal mine dusts. So the individual who has impairment is susceptible because they have the impairment. And there's no evidence in the literature. In fact, it's been investigated and there is no evidence pointing towards susceptibility for one or the other type of insult. And I think that it's helpful to comment on that yes, this individual must be susceptible to lung injury because they have it, but that there is no reason to apportion more of the injury to tobacco smoke than to coal mine dust exposures, depending, of course, on the history. And I would refer you to Atfield Hodis in American Journal of Industrial Medicine.
Thank you, Dr. Patsonk. Again, there's sort of, I guess we're bleeding a little bit into etiology, but because of time, probably I'll reference both at this time the last two topics that we want to discuss. First of all, the etiology of the disease, and as everyone knows, there's a presumption if someone has 10 years of coal mine employment, it's a rebuttable presumption that it arose out of their coal mine employment. Still, there must be some statement, I think, to support a diagnosis of COPD and its relationship, and I think we have case law in the 10th Circuit that's pretty clear on that. So again, I would ask any of our evaluators to include that. And I guess the last thing that I would ask each of the panelists to discuss is, I guess, probably I would deem the most important aspect. That is a diagnosis of whether this condition that has been diagnosed above, that has been linked to coal mine employment, is a totally disabling respiratory or pulmonary impairment. And there are various methods under our regulations under 718-204 that address this. There are various diagnostic tests, spirometry, blood gas study, our gold standard being the exercise blood gas study and those results. And we use the 60% of Knudsen normal values at this time. Maybe we'll revise that at a later date, who knows? And Bob's nodding his head. But that's something we're looking at. But again, I guess on the last issue, and that's where I see most of the cases that end up as being denials. I'm being cut off now. That are being denial or end up being denied, which could be entitled later as the minor. Obviously, if the minor has this condition, there's a rapidity in the declination of function, and at some point, maybe in a later filing, they will be found to be totally disabled. That would be what I would expect. But again, the issues that we're looking at under total disability, did this diagnosed condition have a material effect on that totally disabling respiratory condition? And the other standard under 204, was it a substantial contributing cause? Those or have a material effect in essence. So I would ask each of the panelists to discuss that. Most importantly, look at the objective basis for making a finding that the minor is totally disabled from a pulmonary respiratory condition, and give us some examples in their practice when they're doing these independent reviews for the Department of Labor. So I'll charge you with that task, doctors. Dr. Rasmussen.
Well, it goes to, without saying, the first thing you need to do is to understand the coal miner's job requirements. I do this myself because I can ask questions that he may fail to answer. If you say, what does a continuous miner operator do? Why, he sits on his machine or stands back with the remote and what have you. But that's not all he does. He has to get off his machine and set a timber or shovel a belt, things like that that require heavy and very heavy manual labor. You need to document that in the record so that you can refer back to that when you do your report. Now, if a miner is a coal truck driver, most likely he doesn't do much or if any of that type heavy manual labor. So that'll make a difference in whether he might be considered disabled or not. So you have to match what you find physiologically with the job type that the man did, what he was required to do. For example, you take an old hand loader, and we still see some of these guys, they'd have to be able to work extremely heavily if they made any money. So I don't believe that his requirement would have to be as severe as the standards, the Department of Labor standards say for FEV1, because he wouldn't be able to continue that. So you have to try to match what the individual has done with what your findings are. And then you have to try to relate what you find to what his job was, and to whether you think he is able to continue that job based on what you find in terms of the physiology. You can't just say, oh, he had to do a lot of heavy work and it was hard for him. That doesn't quite cut it. So that aside from deciding whether you think it is related to, his impairment is related to his mining or not, you have to be able to establish that relationship between what you find in terms of physiologic impairment to what his job requirement was. That, I think, is the number one goal that you have to set, or the number one thing you have to answer. Now, we could go into, again, why you think that. Of course, you think so because he wouldn't be able to do this much because his blood gases dropped in such and such a way. So you have to be able to match those things up. But that's the basis of what you must do, I believe.
Just as far as objective, some of our miners don't meet the standard, the Knudsen standards, or the blood gas studies, but they're close or have other indications. And the regulations under 204 allow us to recognize based on whatever, I guess the title of this is reasoned medical opinion. Could you give us a very general idea, in the absence of qualifying studies, what would be the basis for an objective finding, perhaps, of the miner is totally disabled? And again, you brought in the occupational, the amount of effort based on the occupation, and that's vital, especially with someone as strenuously involved in labor requiring to shovel coal, and that person may need, may have reached a different standard. So I just wanted you to briefly comment on that before we turn to Dr. Gaziano.
Oh, yes, that's absolutely true. I mentioned the hand loader who required, all of his work was very heavy manual labor. Now, so far as the relationship, for example, between the FEV1 and his workability, that depends an awful lot on how much breathing he has to do to accomplish a given task. That's why I can't really say someone is normal unless I've been able to do an exercise study. And that is because you can have, everything can be normal, spirometry, the diffusing capacity, but only with exercise will you find abnormality. That is aside from the blood gases, of course, which are important. And again, we always use an indwelling arterial catheter. It cannot be done accurately without. But insofar as the other aspects of that exercise, if you have an individual who has say a mildly abnormal FEV1 that doesn't meet the standards, but he exercises, and his breathing that he has to do to get his work done or to accomplish that amount of exercise in your lab is greater than he can actually accomplish in terms of breathing, or whether he's breathing up to the point where he's reached his limit, then he's disabled. He can't go anymore. So those are the two conditions in which an individual can not quite meet the listings of either blood gas or ventilation, but nonetheless is disabled. But you have to be able to explain why that is, and that's a thing. I might say that sometimes difficult to go into much explanation in a small space that we have here.
We're working on enlarging that, Dr. Rasmus,
That's
with a
good.
new form.
Okay. So those are two aspects. The other thing is you get someone who has 61% of that FEV1. Well, now, come on, is he disabled or not? The difference between 60 and 61 is minuscule. There's nothing really magic about those numbers because, again, here it depends on the job that's being required and the other factors. So everything's not really set in stone. For example, blood gases. If you're a couple of millimeters above the listings, that doesn't mean you're not disabled. And so those are factors that you have to be able to say, well, this man's job was so heavy that even though he doesn't meet the exact listings, he's nonetheless disabled. But you have to be able to explain that, I believe.
Thank you, Dr. Rasmus.
I think what disability means that you're unable to do the job that you're being assessed for. Impairment can be anywhere from 10% to 90%, and a lawyer can do his lawyering work with 80% impairment, but a minor can't do it with 40% most of the time. There is a reference in which how much work each individual requires, and most mining jobs are medium, heavy to very heavy, with the exception of a dispatcher who is described as a sedentary work. And the Department of Transportation has that listing, and that is helpful as a guide. As far as other information that you have, you're allowed an EKG, and that can be helpful. In certain cases, if the P wave is 2.5 millimeters in height, that's a severe lung disease. Or if the heart is shifted to a certain direction with right ventricular enlargement, that's a clue as well that you may be impaired and unable to do your work. The other thing is that a number of coal miners don't have the capacity to do exercise tests, and I was wishing or hopeful that the diffusion test could be incorporated as a part of the examination. Formerly, it was an unreliable test, but currently there's been so many advances in doing diffusion tests, that it is helpful. And not only that, for Social Security disability and the AMA guides, diffusion is useful in determining how much work you can do.
I think those are excellent points. And again, I would just emphasize that the documentation of this is critical. Many of us understand what we're thinking in our own minds. We're legends in our own minds, and we expect that people just understand it because we say it. But as Don was saying, you have to really describe exactly what is the impairment, what is the measured impairment, and then why you think that's disabling compared to their last coal mine job. And again, it's important to get the hardest part of their last coal mine job. Don mentioned this as well. Not just what they did routinely for 6 hours out of the day, but there might be an hour or 2 hours they're doing incredibly heavy work when they get off the continuous miner and they're actually shoveling or hanging curtain, lifting cable, doing things. And so I asked somebody, I just run the miner, but what's the hardest part of your job? Well, actually, I do have to do X, Y, or Z. And then when you write your opinion, mention that part of the job, because they have to be able to do every part of their last coal mining job. And if there's a regular job task that they had to do, even if it was for a short period of time each day, if they can't do it, then they're disabled for their job. And compare that job requirement to their lung function test or their exercise test or their blood gases, and say that that's why they can't do it. And that's very important that you describe that part of it. And I think that most miners, when you ask them how hard was their job, they really just think of the regular things that they did. They don't often think of the very hardest thing. And I learned this from the attorneys who trained me, Tom Johnson, Sandy Fogel, others that really teach us doctors how to take the legal part and put it together with the medicine. And I think that also the importance of doing that for these cases that are borderline in terms of where the measurements fall in with the regulations, if you can express that hardest part of their job. One thing to note too is that when you exercise somebody, the maximum work that they can do isn't equivalent to what they can do for their job, because you can't sustain maximum work for 8 hours a day. So the general rule of thumb that I use is that you can do maybe about a third of your maximum for a sustained period of time for 6 or 8 hours. So if you exercise somebody and they can do a fair amount of work, but they can't really necessarily sustain that all throughout the day. So you should keep that in mind as well. It's not only how hard is it, but how long during the day they have to do it, and put that in your results as well. And I very much like what Dr. Gaziano said about the diffusion capacity, and that's another thing, Steve, that the Department of Labor must revise, because it's very clear for resting lung function tests. If you can't do an exercise test, the diffusion capacity is very predictive of your gas exchange with exercise. It's not 100%, as Don will tell you. There are people with normal diffusions that do have gas exchange abnormalities with exercise, but if you have a very low diffusion, that's very helpful, and it does predict gas exchange problems with exercise. So for miners that can't exercise because of their horrible arthritis and injuries to their legs or to their backs, and we have many people that we can't really get up on treadmills or on bikes, if they have very low diffusion, I've successfully argued in a recent medical opinion that they're totally disabled. So I would encourage, as much as you can, to do full pulmonary function tests. I know we fought very hard to get the clinics in West Virginia and the country full PFT equipment, so they don't just do spirometry. And I think that really is part of what the state of the art should be now for DOL testing, is to include full resting pulmonary function tests and then exercise tests for those miners that are able to exercise. Because clearly a low diffusion test, it predicts who will survive an operation when you're doing lung resection. It's a very powerful predictor from resting PFT, so it's a long past due that we incorporate that.
I agree with Rob. The diffusion capacity is very, very important. A lot of people can do exercise, but diffusion makes a big difference. I think definitely, Steve, we need to change that one, including the full diffusion capacity. And most of the points they already talked, but I want to bring two common things that usually we miss. One is the pneumoconiasis, the age of starting working in the mines, that usually we overlook. The earlier you started in the working in the mines, the more damage in the black lung pneumoconiasis. That we never usually the minor don't tell usually what age is started. The second thing is, this is the federal black lung total disability. The total disability belongs to the last 1 year job. Even though you worked for a roof bolter or continuous miner before, but the last 1 year job is just working as a dispatcher. The breathing test is enough. You may not qualify for the benefits. So the breathing test, whatever thing, even though you have a 30% of breathing test, that is enough for work for as a dispatcher for the last 1 year job. I think that's what is very important. It's only the last 1 year. So it doesn't count when you're working for 10 years back, continuous miner, roof bolter, but last 1 year. That's very, I want to bring it up. If anybody comment on that one, I'll pass on this one.
Make a comment on it. That's true, but sometimes that last 1 year job is given as an accommodation to a sick miner and is not going to count for total disability purposes. So you look at what the miner did before.
Okay. Can you explain one more? I mean, because I was an impression that only 1 year that was Steve was.
That's, it's 1 year. The general rule is that
If a miner changed jobs because of a medical reason,
Right.
in other words, they're sick and they bid on a low exertion job or got an easy job because of medical reasons, then the easy job doesn't count towards disability because they changed it for medical reasons. So then you can use the previous job.
But okay, that's a good point.
If you have documentation
It's a
of that.
documentation, but
Usual and customary job.
that's a good point.
Yeah, the regulations do address the 1 year, but there are exceptions. And I think in the meetings we've discussed those.
That's the exception.
I wanted to go back and just reemphasize a point that Dr. Rasmussen made, is that the disability standard, particularly for the spirometry or the breathing test, is somewhat arbitrary. Remember, often when you're studying a miner, he's been out of the mines for several years. That's given his lungs a chance to maybe recover partially. And that when you study a miner in your office, you're not reproducing the conditions in the mine. Cold air is an irritant and will reduce lung function. Dust is an irritant and will lower lung function. So that if you have a miner who doesn't meet the disability standard, you've got to keep in mind that your conditions are somewhat artificial, and you've got to be able to go back and relate back to his job description and remind other readers what the conditions were in the mine, and that chances are that his lung function would have been lower and would have met the standard were he back in the mine in the cold air and in the dusty conditions. So don't be misled by the somewhat arbitrary values, and you've got to address those miners who don't quite meet the disability standard, because chances are if they're in the mine, they most likely would have met the disability standard.
Let me just ask you a question. It is true that there's a good correlation between cold air sensitivity and methacholine sensitivity. Is there a role for actual measurement of airway hyperresponsiveness in these individuals who have some obstruction but don't meet criteria? As a way of documenting your supposition that they would have bronchospasm.
Good question.
I think that's sort of uncharted territory. I know that there's actually been some great work that you authored on bronchial hyperresponsiveness in miners, and people who are having bronchial hyperresponsiveness having more rapid declines in FEV1. I don't know that it meets the legal standard, though. That's the in terms of if you can prove that they're then disabled if they have a positive methacholine, or you'd probably get arguments. We could try, but I think you'd also then get arguments that it's asthma. From the coal company side would say this is a different disease, that it's not black lung. Certainly, it could be. I don't know. I'd have to ask the lawyers how they would handle that.
It would be debatable as far as a reasoned medical opinion. So
I think you could make the argument, but I don't know how it would play out in court, and I don't know if any of the attorneys here have had cases like that where somebody has normal or not qualifying, or not even borderline lung function, but have positive methacholine challenge tests. In
I've
other
never
words,
heard of it.
we show that they're asthmatic. I don't know if you've had a case like that, Sandy, or any where you've been able to win those kinds of cases.
I mean, let me.
Never with that particular issue, but we always go back and rely on your reasoned medical
Right.
opinion.
So, I mean, we could say that I've said in many state claims that they can no longer work in the atmosphere of a coal mine, and they're disabled from going back to coal mining. But that, I don't think it's the same standard for federal
Right.
cases. So for state workman's comp, we always, you can say something like that. The question for us is, can the miners safely return to the atmosphere of a coal mine given their impairment? And if they have bronchial hyperreactivity or they have some sensitivity, we can say no, they can't. But I don't think that meets the criteria, or that's probably arguable for litigation for total disability under federal regulations.
One question, you're referring to 8 hours a day. Most people in the industry today, there are no 8 hours a day. And most of it is at least 10, most of them are 12. How do y'all look at that? I mean, it's not, in stone that we work 5 days a week, 8 hours a day. It's more or less now. It's just right over and over and over. It's more like 6 days a week, 12 hours a day, or at least 10 hours a day.
Go ahead.
But the longer you have to sustain physical activity, the lower percentage of your maximum you can sustain. So say you can do, the term for how much work you do is, one is called METs, how many METs somebody does. And a stevedore, or somebody doing heavy coal mine work, might do 8, 9 METs of labor. But if you have to sustain that for a whole day, you can only maybe do 1/3 of that. So maybe you could really sustain, 3 or 4 METs over 10 hours or whatever. So the longer you have to sustain it, then the less you can do continuously. If there's short bursts of very heavy labor, then you can do that longer. I think that also, that point, so I think that that's just in general for exertional requirements. The heavier the exertion, then the easier it is to call somebody disabled, and the longer they have to do that heavy exertion, the easier it is. So, and the other thing that goes to, though, is really something that people are looking at, and Dr. Petzonk and our scientists from NIOSH are looking at, is exposure, because people that are working all these double shifts, long shifts, don't have, their exposures are probably more significant. So the same number of years of work at huge extended work shifts is much more exposure than it would have been. Say 10 years mining under these conditions is much worse than 10 years of a miner who could work an 8-hour shift only. Because if you're working 16 hours, you have double the exposure and probably even a more of effect of not being able to clear the dust. So I think that's important when you describe it. In my reports, if people did a lot of overtime or extra hours, we talk about that really as it goes to exposure, that their exposure is even more significant.
Thanks, Bob. And I think a lot of that is incorporated in MSHA's new regulations. They talk about exposure levels, et cetera, and I think that will be very helpful when they're able to actually get that out. I think to address the theory that was Dr. Petzonk discussed, that's the basis of a reasoned medical opinion. It can be, that you're free, the physician is free under our regulations to provide a reasoning that can be tested. Of course, the other side can bring their expert witness to discuss it, but certainly if you have an objective basis, that's all we ask in these reports. If you're going to give us your opinion, make sure you give us an objective basis. Some people, Dr. Rasmussen discussed close values under FEV1 with a miner who has a job with high exertional requirements. That to me is reasoned, and a judge would deem that perhaps as reasoned in the absence of rebuttal evidence. That's, I think, what we want to project in this panel discussion is give us your opinions, but make sure they're reasoned, and so that a judge up the line can understand exactly what your rationale was. And even godlike or not, Bob, as you've indicated, it's essential. We've had some physicians that I've met with, they said, well, we've discussed reasoned medical opinions as I've gone around the country, they said, well, I've had 30 years of examining patients, and the judge is just going to have to believe me. Well, that's not going to work, and that does an injustice to the miner. And it also does an injustice to our requirement under 413B to give the miner some kind of opportunity to substantiate their claim. And we're going to reject those opinions, and we have rejected them until the physician supplies us with an objective basis. And that's the reason why we're trying to do some outreach with training such as this, and I thank our 6 participants. I would ask, I guess, for the last couple of minutes, if we want to pass this around and talk about etiology. We sort of skipped over it, and then we'll take questions for whatever time we're allowed. And I know we have some people that jump me on time, so we'll make it quick. Dr. Rasmussen.
The etiology, of course, it's helpful to be able to understand the pathological mechanisms that destroy lung tissue. For example, Dr. Petzak mentioned the cigarette smoke and the coal mine dust. Well, the reason you think they might have the same susceptibility is that both the mechanisms are the same. In other words, the pathological mechanisms are identical, so that you know that. You understand that coal mine dust can also cause interstitial fibrosis, and that makes a difference in terms of what you're trying to explain what you find. For example, the blood gases, when they're done properly and they're abnormal with exercise, that could be the consequence of both emphysema and interstitial fibrosis. So that if you're able to tie in what you know about the pathology and the pathologic the results of that pathology, it helps you in identifying an etiology. Now, we have to bring in here the not only the etiology, but the differential diagnosis. For example, you very seldom have an individual in the age of the minors that we see who have just one single illness. Many of them have other conditions. For example, one of the biggies is heart disease. And how do you distinguish between the effects of heart disease and the effects of lung disease? That has to be taken into consideration. There are ways that you can make a pretty good judgment about that. One of them is not arterial blood gases. Heart failure does not cause exercise hypoxia, but that could go into another subject. You have an individual, for example, with rheumatoid arthritis. Now, we know rheumatoid arthritis can cause lung disease, and it can actually be very similar to what you find with coal miners. So you can't say, well, it's coal mine dust and not rheumatoid arthritis, but since it's the same kind of process, you can say, well, look, how can you distinguish? You can't distinguish between smoking and emphysema and coal mine dust. How can you distinguish between the effects of rheumatoid arthritis and coal mine dust? You really can't on the basis of what you have, because they both do the same thing. So those are features that you have to be able to bring into the operation here. It's not simply a matter of saying, well, he worked in the mines and therefore. Now, the X-ray, it's a nice tool to let you know that an individual was exposed to coal mine dust. With clear evidence. His coal mine dust is in his lung. That does not prove, in fact, first of all, it doesn't prove he has an impairment, and it doesn't really prove that his impairment is due to his coal mine dust. You have to be able to relate why you think that's the case.
Exactly.
There's one other disease that brings up issues as it relates to coal mining, and I think basically the Federal Register indicates that tuberculosis, silica tuberculosis, can be considered a occupationally related to coal mining. And so the people who have scars that can be either TB or black lung, or most commonly the combination, I think the issue and the case can be made that it's related to their their occupational lung disease. There's one other point that's very important, I think, that if you've had lung surgery and the pathologist comes back with pneumoconiosis, that you should bring it to the examiner to help him establish your case. And one case in particular, and this has happened more than once, that someone brings in a specimen that shows that he has a large pneumoconiotic nodule removed. So the man had complicated pneumoconiosis, which is an automatic allowance. And then the issue from the other side is that, well, he was cured by the surgeon. I don't buy that, so but it's important that you have the pathological report with you so that the physician could make a better case for you.
That's an excellent point. Actually, just an advance notice, tomorrow Dr. Clapp is going to give a whole talk on TB and silicotuberculosis and black lung and TB, so stay tuned for that tomorrow to get a lot more detail. I think that this whole question of etiology means saying why you think coal dust caused it, but then, as Dr. Rasmussen said, listing all of the other things that can be confounded or confused with it and taking them into account, either explaining why you think that they're not the cause of this, or explaining why you think coal dust is still a contributing or important cause of it. So if it's somebody with restrictive impairment, taking into account their obesity or their heart disease or their thickening of the lining of their lung or anything else that could cause restriction, and explaining it or saying that you thought about it. For obstructive lung diseases, it's taking into account their tobacco smoking, their environmental exposures to other things. So you can't ignore all the other things that could cause these diagnoses. Make sure you list them, make sure you talk about them, and explain how they fit into the picture. Sometimes we've used the term in the past that people are trying to explain away coal dust by saying that their diseases were caused by anything but black lung. And we used to jokingly call that ABBL disease, anything but black lung disease, to explain their findings. But it's incumbent upon us to explain very carefully why we think that black lung did play a role and that these other diseases either don't exist, or if they exist, don't rule out black lung as a significant cause. And I just would like to make one final point, that is that we want to be very good advocates for our patients and do that, do a good job and do this well, but we can't overstep the bounds of science and rationale, so that we're doing a disservice for people if we just examine hundreds of minors and say they all have black lung because we said so. We're really not serving anybody very well. So we have to make sure that we do very high quality medical exams, very scientifically based, justified in the literature and rationale, and don't do something just for no reason, just to think you're helping somebody, because in the end you're not going to help them.